Righty. I think we have everyone with us that needs to be here. So I believe Counsel Ms. Berger, you are the appellant in this matter. Did you want to unmute and did you wish to reserve any time?
Yes, thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal.
Thank you. You may proceed, Counsel.
Thank you. May it please the court, my name is Erin Berger on behalf of the appellant in this case, Carlos Guzman. Mr. Guzman sued Southern Fidelity Insurance Company with regard to a property insurance claim that resulted or that stemmed from a leak in a bathroom in his home. In the trial court, the insurance company moved for summary judgment on the basis that Mr. Guzman did not comply with conditions precedent to filing the suit or conditions of the policy, particularly with regard to providing prompt notice of the loss and whether or not he showed the quote unquote damaged property in this case. We've raised and addressed those two issues as points of error by the trial court in granting summary judgment, and the appellant requests that the court reverse the entry of final judgment in favor of Southern Fidelity and reverse and remand to address these remaining issues of fact. The insurance company and Mr. Guzman agree as to the analysis that applies to whether or not prompt notice was given in this case. And that's a two-step analysis. And the first step is to determine whether the insured materially breached the policy by giving late notice. And if notice is determined to be untimely, whether there was prejudice to the insurer. It's appellant's position that the insurance company's argument is incorrectly premised on the conclusion that the notice was untimely, but we believe that there's genuine issues of material fact here that the notice was promptly given. This court, yes, ma'am.
Let me interrupt you here. First of all, I want to clarify something that's not clear to me from the record. The invoice from heirs was for approximately $6,000, correct?
Yes, Your Honor.
But the claim for damages is for $21,000, which I understand that the repair estimate from Contender was also for $21,000.
I believe that's correct, Your Honor.
Was $6,000 worth of work done before the insurance company was notified, or was $21,000 worth of work done before the insurance company was notified?
I don't believe that the issue of damages was much disputed, but
I'm not talking about damages per se. I just want to know how much work was done before anyone called the insurance company.
The $6,000 invoice from heirs is just related to the water dry out procedures that were taken. And it's sort of unclear to me from the record, but my review of it suggests that perhaps that's for both the claims that Mr. Guzman had related to his kitchen and his bathroom.
Okay, perhaps I'm not being clear. And maybe this is one of the reasons this case isn't ready for summary judgment, but I'm trying to get an idea of how much work was actually done. Was it $6,000 worth of work? Was it $21,000 worth of work? And not focusing so much on the specific number amounts, sure. But how much work was done before the insurance company was notified?
Heirs did $6,000 worth of water mitigation before the insurance company was called. The $21,000 is an estimate from Contender that
for future work down the road,
for work that needs to be done to bring the property back to its pre-loss condition.
Okay, so the only work that had been done at the time the insurance company was notified was the mitigation, the remediation work.
Yes, Your Honor.
Okay, thank you.
And I believe there's another invoice in there, Your Honor, for $200 related to the plumbing repair that they did. So a little over $6,000.
Okay. So my next question for you, now that you've cleared that up, thank you, is what is the purpose of the notice requirement?
The purpose of the notice requirement, as the insurance company has argued in their answer brief, is to provide them with an opportunity to investigate, to give them notice before, to give them notice so that they're able to investigate the claim to avoid any issues of fraud or any issues of further damage and those types of things. And here, the appellant complied with his policy by taking mitigation efforts to prevent further damage to the property. And the cases that are primarily relied upon by the insurance company in its argument below and in its answer brief involve very distinguishable issues or factual circumstances. For instance, the Yacht Club case and the PDQ case and the Morton case, those all involve cases that were, they were months or several years down the road from the claim. In the Yacht Club case, the 11th Circuit made a point of noting that, the board of the association there knew that there was damage immediately, set aside $150,000 for assessments to prepare the damage, but also that they admitted that there was damage that occurred between the time of the original loss and the time that they reported it. And that's part of the prejudice issue that comes up is was there some intervening damage that had taken place? And same with the PDQ case. In that case, there was no contention that there was some damage that had occurred or deteriorating condition or worsening conditions between the time of the loss and the date that it was reported. And here we don't have.
Let me ask you this, because if the purpose of the prompt notice requirement is so the insurance company can come in and investigate, for example, the cause of the damage, not even necessarily whether damage is ongoing, but to ascertain the cause, then as a matter of law, why wouldn't the notice be untimely if they have not been notified until after their ability to conduct that investigation has been thwarted by the amount of work that's been done?
I don't believe that the purpose of the notice provision is solely related to whether or not they can determine the cause of the loss.
Well, no, but it's you said it's so they can conduct their investigation, and wouldn't the very first step in that investigation be to ascertain the cause of the loss?
It would be one of them, Your Honor, and to determine
if there's coverage in the first place.
I'm sorry, Your Honor.
To determine if there's even coverage in the first place.
Yes, but there are circumstances here that create issues of fact as to whether or not, that investigation was done completely, whether or not they did even a full and complete investigation, whether or not, the case could be proven through other means if they're claiming, and as they do, that they weren't able to determine the cause of the loss because of the damage, the faulty plumbing part being removed. And I would refer Your Honor to the Restoration Construction versus Safe Point Insurance case. In that case, the facts are almost identical to what we have here. And the 4th District Court in that case determined that there were genuine issues of material fact to be determined, even though the insurance company made the same arguments that they weren't able to determine the cause of the loss because of the notice issue and because of the plumbing part being no longer available to them. In that case,
the problem in that case, I think, is that even after being notified, I guess it was 5 days later, the insurance company sent out their adjuster, but then it was another 12 days later before they actually sent someone in to do an inspection. And therefore the question was it the failure to give prompt notice, or was it the insurance company's decision to sit around for another 12 days before it got down to the site to check it out? That was my understanding of what the question of fact was.
And I don't really understand, respectfully, I don't see the difference in the case here, because here we had a date of loss on March 25th. It was reported 7 days later. In the Restoration Construction case, it was 5 days. So we're just talking about a difference of 2 days there. The first inspection here took place the same amount of time after it was reported. So 5 days in Restoration Construction and 5 days here. And I would argue that in the reconstruction, the Restoration Construction case, they had more evidence and there was more of an investigation done, because here there was never another inspection by a professional engineer as there was in the Restoration Construction case. And there they had the experts report that said, we're really unable to determine what the cause is here. We don't have that here. They never did a subsequent investigation with a professional engineer.
Right. And isn't their position they never did a subsequent investigation because all the work was already done and they couldn't see anything? And what's the point in sending out a professional investigator if there's nothing to investigate by that point?
Because they didn't do enough of an investigation. They've relied on the same arguments that were presented in that Restoration Construction case.
Except the distinction is they sent it. Couldn't you read that case as saying, well, if they're sending out a second team in the restoration case, or reconstruction case rather, that's because there was still something worth investigating. Their adjuster came out and said, wow, we got to get our team out here. And the team took its time getting out there. And that was the problem. In this case, if I understand Southern Fidelity's argument, the inspector went out there and said, there's nothing to see here anymore. It's all been done and the parts have been thrown out. There's no point in doing a further investigation because there's nothing here to see. So doesn't that actually cut against your argument?
I don't think so, Your Honor, because as the facts that are laid out in the 4th District case, they're the same as here. They made the same arguments, that they weren't able to make any determination.
They made the same arguments, but my point is the facts are different. The undisputed facts are different, aren't they?
The facts are different in that the insurance company there did more of an investigation. The record isn't clear as to what, if anything else was done, other than they sent their field adjuster or their field inspector, who's not a professional, who, there's nothing in the record to say what he determined. Even there wasn't any notes or anything attached to their motion for summary judgment. There's nothing even to say that he made that determination that Your Honor is assuming was made in this case, or that wasn't made in the restoration construction case between the field inspector and the professional engineer. There's nothing to say that that determination was made, excuse me, by that field inspector. I think maybe that inference can be made, but in a motion for summary judgment, all inferences need to be made in favor of the non-moving party.
True, but don't they have a presumption of prejudice that needs to be overcome?
They don't have the presumption of prejudice unless it's determined that the notice was untimely, and we would argue here that we just don't have that. None of the cases that were cited.
Logical. Well, no, it doesn't. You're right. There are two separate inquiries. Okay, let's keep them separate then. So I understand. So you're saying I jumped issues, and you're probably correct. So.
Correct. And that's what I was saying before about the insurance company's argument is based on the premise that there's been a determination and that it was appropriate to make the determination as a matter of law that the notice here was not.
Does the factual record in this case demonstrate that before notice was given, the site had been repaired and closed up?
The site had been, heirs had done mitigation work. I think that included some holes being bored into the walls, the removing of baseboards. I don't think any repairs were done other than what they did to address the water issue, Your Honor.
Are you suggesting that the record shows that the alleged location of the claim was still visible to the adjuster to look at?
I think that inference can be made, although I'm not sure that it's expressly discussed.
Well, I'm trying to take, make sure that I understand, because I think the question that Judge Rothstein-Yoakum made is if everything has been done, it's closed up, and the parts that were, alleged to be damaged are discarded, what exactly can the insurance carrier expect to find? There is no notice then. You can give notice to come see what we did, but not to see what the cause was or what the situation was contemporaneous with the repair. I'm concerned about that.
Obviously, Your Honor, that's an issue, and that's why they denied the claim. But we would argue, and Mr. Guzman presented an affidavit here suggesting that in his deposition, he let them know, the people that might know more about this or the people that you could get this information from are heirs, contender, perhaps his wife, who was also at the property, but they haven't presented any evidence here that they did any further investigation beyond sending their field inspector 5 days after the loss. And based on the restoration.
Go ahead.
I was just going to say, based on the restoration construction case, that was enough to find that genuine issues of material fact remain for the determination by the jury. If I could continue just briefly, Your Honor, the insurance company makes all these arguments about, these points in time of when a reasonable person would have known to give a call to the insurance company. But those are issues of fact. There's several things here, whether or not he should have known, because the service providers he contacted had insurance in their name. I mean, that's up to a jury. That's not a matter of law here.
So how long before from the discovery to how much time elapsed from the time of the discovery of the problem to the restoration company, the AIR who dried everything out, right? How long did it take for the insured to call that company and for them to come out and do the mitigation?
Your Honor, the record reflects that a coworker of Mr. Guzman's referred him to Contender, and Contender contacted heirs. And if I could look at the invoice for heirs, I could tell you if it was the same day as the notice or if it was a different date. But it was within it was within the same day or the next day that Ayers came out to address the water issue.
Okay, so Ayers, they come to dry out. So there's a lapse in time between the time of the discovering the problem to the time that the company comes to take away what could possibly be considered evidence to that of what the attributable cause was, which is where the water is. And so that was a day or two.
Your
And
Honor,
then how long after Ayers was there did they, I mean, it was a week. So that means somewhere in between that week, Ayers came out.
Wasn't it 3 days for Ayers to conduct all of its remediation work?
In record site, page 255 is the daily humidity record that was attached to the response in opposition to the motion for summary judgment. And that shows that they began their work on March 25th and they completed their work, it looks like, on March 28th. So 4 days total.
But and you add the delay of getting them out there, of which may have been a day. Okay.
And so it was reported on April 1st.
Yes, Your Honor. And again, the record reflects that Mr. Guzman relied upon Contender for what his next step should be. They contacted Ayers, referred Ayers, and he hired Ayers. They referred him to an attorney. He contacted the attorney, and I think it was the attorney that made the initial claim to the insurance company. So he was relying upon the professionals that he called to help mitigate the
Pardon me to
damage.
interrupt. I forgot to let you know that you were at 15 minutes. So I'll charge it to me, not to you, but you're past 15.
Sure. And I will just briefly conclude here in pointing out again that we believe it was an error to determine as a matter of law that 7 days notice from the loss as a matter of law violative of the prompt notice requirement. Therefore, the insurance company was not entitled to a presumption of prejudice and was required to demonstrate how they were prejudiced here. And we would argue, based again on the restoration construction case, that there's room here to find that genuine issues of material fact remain as to whether or not the insurance company was prejudiced, because they didn't do any, there's no record of any further investigation, or it's unclear what they did other than send their field inspector 5 days after. There's no discussion of why it took them 5 days to send them, as was an issue in the restoration construction case. And I'll reserve the remainder of my time, Your Honors.
Very well.
All right, thank you, Your Honors.
Counsel, before you begin, since I made a mistake, I don't intend to give one side because of the matter get more time than the other. So you will be given an extra minute.
Okay, thank
Yes.
you, Your Honor. The specific purpose of a notice provision, as stated in the Laster v. United States Fidelity and Guarantee Company case, is to enable the insured to evaluate its rights and liabilities, to afford it an opportunity to make a timely investigation, and to prevent fraud and imposition upon it. And Your Honor was exactly right to bring that up, because that is directly why we moved for summary judgment at the trial court level, and why the trial court granted summary judgment in our favor on the notice issue, because we were prevented from having that opportunity to do all of that. And the idea that the reporting delay was only 7 days is that assumes that the actual loss occurred on March 25th, 2016. However, there's evidence in the record that it could have occurred and likely occurred before then. Specifically, the plaintiff testified that he discovered mold in the property, and mold typically doesn't happen overnight or let alone a week. And also, at his deposition, he could not remember definitively when he discovered the loss, how the loss was discovered. He doesn't even remember finding an active leak or puddles on the floor. He just knows that on March 25th, 2016, he authorized his mother to sign a contract with Ayers, and he was told by a coworker in response to him telling him that he had a problem with a leak that he should contact Contender Claims. So this idea that there was only 7 days, again, presumes that it actually occurred on that date, which there's evidence it was much earlier. But even if we give him the benefit of the doubt, it's Southern Fidelity's position that the amount of days is not what's determinative here. It's what happens during those amount of days that could be determined, that is determinative of this issue. And to that end, as we argue in our brief, there were multiple points at which a reasonable and prudent person would have known that a claim for damages had arisen here, and Mr. Guzman failed to satisfy that standard at every step of the way. A reasonable and prudent person would have known that a claim for damages had arisen when he discovered that there was mold in a property, or when he knew that he had to call a loss consultant, one which particularly had the word claim in its name, or when that loss consultant tells him that there's damages here and he needs to hire a restoration company, one which has the word insurance in its name.
Mr. Bernstein, let me stop you there, because if you look at the case law in Florida that holds as a matter of law that notice is untimely, those cases all deal with months-long periods or even years-long periods. So obviously the temporal component by itself factors in. Otherwise, there wouldn't be any point in having a two-part test. It would simply be if the insurance company can show it's prejudiced, then it's not prompt. But there's a two-part component. First, you have to establish that it's untimely. So we would have to affirm, we would have to write an opinion saying 7 days is untimely as a matter of law if. And so what specific ifs, because this would be a considerable departure from the case law that exists, especially because most of the case law says that whether it's prompt is a jury question, and summary judgment is not favored on that question. So what would our opinion affirming say? 7 days is not prompt as a matter of law if. I mean, you call an insurance company that, or a restoration company that has insurance in its name? I mean, is that, what would we be holding here?
First, while the cases that affirm summary judgment as to the notice issue, the notice periods were perhaps in months. There were cases in which periods of early as a few weeks in Florida have been deemed to be late notice. But to that end, I would answer your question by saying that your holding here doesn't even need to have a number in it. It just simply has to state that notice is not prompt when a reasonable prudent man would have known that a claim for damage has arisen. For example, like here, when a claim that resulted in $6,000 worth of remediation damages occurred, or when destructive repairs are made to the property, that warrants notice being untimely, or when the insured's loss consultant estimates that over $21,000 of damages. It doesn't have to be a specific number as far as
it has to be a specific number, because how long after coming to that knowledge does the call need to be made to the insurance company? What if, you talk to those entities and then you had to take your children to school, and then so you didn't get around to calling the insurance company for a few more hours? Is that also untimely?
No, but not in that situation. But it's untimely when we are prevented from confirming what you were telling us about the loss. If you are telling us that this loss occurred because of a faulty plumbing part, then notice is timely if you notify us to within enough time to allow us to confirm that cause of loss. Similarly,
I think go on, Judge Atkinson.
Go ahead, Judge.
But I think the plaintiff would say, well, you never asked heirs if they've got pictures. We don't even know at this stage of the litigation, this early stage, whether you have been prevented from investigating the loss. You just said you have. You didn't attach pictures to your motion for summary judgment showing anything. You didn't. I mean, all we have is your word that, we're not going to be able to tell. And on the other side, you've got the plaintiff saying, you didn't even ask the people who did all the work. You haven't asked them for pictures or anything. So you're asking us to sort of take your word without the summary judgment evidence that you have been completely precluded from conducting your investigation.
Not quite. The plaintiff, in their response to the motion for summary judgment, put before the record not only an affidavit of the plaintiff, but also attached a copy of our claim determination letter, which was properly before the court in considering our summary judgment. And in that claim determination, we outlined a very large extent of the investigation that we completed, including taking an examination under oath of Mr. Guzman prior to filing suit. And we dictate in that letter how we sent him multiple requests for information and materials, including the photographs that heirs may have taken prior to them performing their services. And Mr. Guzman never provided us with those documents. So that evidence was properly before the court and led to to Southern Fidelity's decision to deny the claim.
So let me proceed on that one. As I understand the decision on this area, it's a two-pronged test. And the first is whether or not the notice was given timely. And it's not until that legal question is answered that we can or should move to the second prong. So if we assume that that has to be the first determination, how can you have a complete final summary judgment on the second issue before the trial court has established as a matter of law that there's been a lack of a prompt response, thereby requiring the policyholder to show that you have no prejudice? Some of the facts that we are talking about, photographs and stuff, may also apply to that prong. I have to confess, I'm not certain how the trial court, consistent with the two-prong test and consistent with due process, can make an order that says simultaneously, A, notice wasn't prompt, and B, you can't refute it, when the first issue is the key to the second one. At best, this should have been more arguably, in my view, a motion for a partial summary judgment. And that's just assuming that the trial court was correct on the first prong. How can you get to the second prong on this record?
And also, I'm
Go ahead,
sorry,
please.
just to follow up on Judge Castanueva's question, it seems to me that your approach is sort of flipping the test around, and that if we are prejudiced, therefore it is presumptively untimely, and that's contrary to the case law.
Right, and that's not what I'm trying to do, Your Honor. We agree that it is a two-step analysis, and we believe that the trial court appropriately analyzed both of those steps and ruled in favor of Southern Fidelity. Here, as to the first analysis, the plaintiff wholly failed to satisfy the reasonable prudent man standard to satisfy that first prong. At no point in time, through a variety of events that occurred, did he or his representatives contact Southern Fidelity. And because of that, because there are multiple instances where a reasonable prudent person would have believed that a claim for damages had arisen, that the court properly entered summary judgment for Southern Fidelity on that issue, which then triggered the second issue. So
how could the court, by doing this twinkling of a legal eye, preclude the appellant from being able to present evidence to show that there's been no prejudice when it wasn't until the moment the judge affixed her signature to the order that the law of this particular case, an interlocutory ruling, had been made that under the circumstances, prompt notice wasn't given? I mean, they had no notice of that this duty was going to be imposed upon them until the trial court so ruled.
I would disagree with that, Your Honor. He was acting under this obligation from the moment he signed his policy. He had that obligation to provide prompt notice. I'm talking
about the trial court making a ruling on a summary judgment, denying someone a trial when the interlocutory ruling that notice wasn't prompt was made simultaneously with the determination that there's been no prejudice, not allowing the appellant to have any opportunity to present evidence that would follow, because it's a rebuttable presumption, and it doesn't come into being until the trial court, in my view at least, makes a determination by answering the first question, the first prong.
Well, Your Honor, they had the opportunity to present any evidence to rebut the presumption at the summary judgment level. They filed a response in opposition to the motion for summary judgment, and all that they submitted to the court was documents from heirs and their loss consultant, as well as our claim determination letter, and a affidavit from the plaintiff. And the plaintiff's affidavit did nothing more than confirm the timeline of events that we proffered on our motion for summary judgment, and basically said that he did his best. He relied on his representatives, and that somehow
I understand that. So I said I'm prepared, for the purposes of my question, to concede the first prong was met. My concern is once the trial judge says notice under the circumstances did not comply with the policy, it was not prompt, that becomes the legal determination that governs that case. And it's not until then, I would think, that notice is provided to the appellant that now the burden of law has shifted to you as a matter of law and fact. And I think it takes a two-part summary judgment, if you will, taking the first one and then notice and due process is given to understand the second one. So you can take depots or whatever you need to go in, who's got pictures, when were they pictures, when were they tendered, and that thing to try to establish the lack of prejudice. And I apologize if I wasn't clear, but that's my concern, intertwining the prongs, the second prong with a due process concern.
All right, and I understand your point, Your Honor, and I get why you're saying that, but I don't think that it has to be separated to that extent, particularly when both issues are raised in our motion for summary judgment. I think that they had an opportunity, if they wanted to take depositions of more people, to do that before the hearing. They had the opportunity to conduct more discovery or present
So they could have
additional
asked the
evidence.
trial court to bifurcate the proceedings to determine who wins the first one or not.
Correct, and they did not do so.
Mr. Bernstein, one thing that troubles me is the burden doesn't even shift to the other party in a summary judgment proceeding until you establish that there are no questions of material fact. Then the burden shifts to them to come forward and say, well, yes, there are. So what is it that you presented that established that there's no issue of material fact?
We presented evidence in the form of the plaintiff's deposition in which he confirmed that he had contacted Contender Claims before notifying us, that he hired all insurance restoration services before contacting us, that there was mold in the property before then, that Ayers had performed and completed all of its restoration services prior to us being told of the loss, and that the allegedly faulty plumbing part had been replaced, removed, and discarded prior to notifying us. All that is undisputed and before the record. And because of that, that is all evidence independently, but certainly in conjunction with one another, undisputed evidence that satisfies that first prong.
Okay, so
Let me ask you this, is it possible, go ahead.
so we'd basically be writing an opinion that says, if you have complete all your remediation work and throw out the parts before you call us, then the notice as a matter of law is untimely. Effectively, that's okay. Okay.
Yes, Your Honor.
Go on, Judge Atkinson.
Well, would you agree that it's possible that there could be timely notice and still, and at the same time, the insurance company could suffer prejudice due to the time that elapsed? In other words, let's say it was a day, and then later that the insured notifies the insurance company. Yet in that day, there was through no fault of the insured, there was a spoliation of evidence of whether the claim is covered and the cause of the claim. I don't know, the house burns down or it was smoldering and then everything turned to ash and you couldn't. Is that possible?
I believe in that case.
In other words, the prejudice prong, that you suffered prejudice. I wish you'd called me yesterday morning while the house was on fire. But yet still it's a day and it's not really reasonable for an insured to call the insurance that day.
But that's exactly why the number of days or hours is not determinative here. It's what happens during that number of hours or days that is determinative. And in that situation, Your Honor, you're exactly right. If the home is somehow destroyed in between the time the loss occurred and when we're notified, even if it's only a period of a day, notice is still untimely because, again, we are still not able.
Oh, it's untimely. I was saying something different. I was saying, could it be timely? Meaning, in other words, it sounds to me like you're still conflating prejudice with timeliness, which the mistake I made during the presentation of the appellant's argument. So I'm saying, isn't it possible that there could be prejudice suffered by the insurance company due to the elapsation of the time between the loss, the knowledge of the loss, and then the notice, and yet it still be timely?
Sure,
what determines timeliness? Prejudice?
No, timeliness again is when a reasonable, prudent person would have believed that a claim for damages had arisen.
You just said that even though it was a day later, it's untimely because, I'm sorry, their house burned down and we can't figure out why now. If you had called us while it was burning, that would be timely.
Right, but there probably are situations where notice may be timely, but still some prejudice may be caused. But in that particular hypothetical that you raised, it's the fact that there would still be an event that we can no longer confirm or deny happen because of that. And at that point in time, if the loss created such an extent of damages that you later had to hire somebody to come in to fix it to the tune of $21,000 or $6,000, that would still be untimely, even if the house was later raised. So separate prejudice from out. If you discovered you woke up one morning and found that your entire house was flooded, but still waited several hours, that's still, in my opinion, would still be untimely.
So it's not just prompt notice, it's immediate notice.
No,
basically.
no, it's not requiring.
As soon as the water starts pouring through your ceiling, you better be on the phone with your insurance company, is what you're saying.
No, I'm not saying that, Your Honor. I apologize if that's how it came out. What I'm saying is that, again, if a reasonable person says, "Oh, this has happened, and I should really call my insurance company," or "I need to go call this company to come out," or "I need somebody to fix these damages," if that occurs, then that is when a reasonable person would believe that a loss has arisen. If it doesn't require immediate notice at all, it's just at a point in time where a person would think that this has risen to this enough of a level that it could lead for a claim for damages.
Well, isn't it sort of a question as to what that level is? I mean,
well,
is it
held
after we?
not.
I'm sorry.
Several courts have held that it can be determined as a matter of law that notice was not prompt, and particularly when the evidence before the court as to what occurred is not disputed, which is not here. We know what happened before we were notified of the loss, and so it doesn't matter. Shouldn't matter when the loss. When the reporting actually occurred as far as days goes, or number of days. Again, it's all determined by what happened during those days.
And in computing the days, don't we start with the date that the injury was discovered?
Say that again, I'm sorry?
In computing the time for prompt notice under the policy, do we not begin the analysis with the date that the record shows the claim area was discovered?
I think that is a fine area to start, and that could be the basis of the analysis here for sure. But again, there's very little indication that he actually discovered it on March 25th, 2016. That's just the date that he decided to hire heirs for it.
Judge Atkinson, you're muted.
The court in restoration instruction linked the insurance company's dilatory investigation after notice, not just to prejudice, but to timeliness. Should we follow that logic, or is that an improper conflation of prejudice and timeliness?
We believe with respect to the 4th DCA that they got that analysis wrong, and they were doing what you essentially initially thought that I may be doing, which is putting the cart before the horse. They were connecting or conflating the fact that because there was a dispute of fact as to what prejudice was caused by the delay in the inspection, that meant as a matter of law that there was no timely notice. And there are, in addition to the distinction that Your Honor Rothstein-Yoakum brought up before about what was the point of a second inspection. By that point, there's other distinguishing factors as well that bode well in favor of Southern Fidelity here. For instance, in that case, SafePoint didn't actually really reach a conclusion. They just said that they were unable to confirm the water damage, and therefore they did not deny or afford coverage. In this case, we actually made a claim determination. We reached a conclusion, and we said that there was no coverage for the loss based in part on the failure to provide notice.
Permit me to interject here. We're even now beyond the 21-minute point the extra time that was given. So I need to ask you to summarize in about 30 seconds, if you would.
All right, thank you, Your Honor. Your Honor, it is clear from the facts, the undisputed facts of this case, that a reasonable prudent person would have known that a claim for damages had arisen at multiple points prior to us being notified of this loss, and that wouldn't have changed wouldn't have changed at all as to when we went out to the property. That's completely irrelevant fact as to when we finally got out there, because the prejudice had already been done by the late reporting of the loss. And so on that end alone, the summary judgment entered in favor of Southern Fidelity should be affirmed. And likewise, the same facts support the second argument of summary judgment, which is that the insured failed to show the property at issue, and the summary judgment entered in favor of Southern Fidelity on that issue should also be affirmed. Thank you, Your Honors.
Thank you, counsel. Okay, we'll return now to the appellant. I think you have 4 minutes.
Thank you, Your Honors. I think the restoration construction case properly delineated the difference between the two prongs of the prompt notice requirement. The issue being whether or not prompt notice, and as counsel has stated, whether or not a reasonably prudent person would have, or what would have prompted them to make the call. I think Your Honors are correct that there's somewhat of a conflation between the two prongs here by imputing prejudice into the notice issue. But I think looking at the restoration construction case, we have the same facts here where they found that there was a genuine issue of material fact as to whether or not notice was prompt. There was a loss. The insured person contacted mitigation service providers, then gave notice. Then there was an inspection, and that's the timeliness issue. That there's a genuine issue of material fact, and then we get into the question of whether or not there was prejudice. There is.
So are you saying so? That all sounds consistent with well, let me ask them my same question. I don't disagree with anything you just said, but the restoration construction case did rely on the dilatory investigation by the insurance company to conclude that the determination as a matter of law that it was not prompt was incorrect. I want to know whether you're urging us to do the same. So the fact that the insurance company in restoration construction and the insurance company in this case took a little while to send out, whoever. I mean, assuming that there was dilatory, how does that establish that the time that this insured took to notify the insurance company was unreasonably long?
I'm not sure I understand your question, Your Honor.
Okay, so in other words, the fact that it can be argued that the dilatory investigation suggests that there's no prejudice, because if you just sat there and waited to come out, obviously you weren't prejudiced. You did not come out and investigate with alacrity, insurance company. So how can you say now that you were prejudiced by the delay I took in notifying you? So, but my question is, how does that has to do with prejudice? But how does that establish that it was an unreasonable time in which the insured took to give notice?
I believe that the timeline that the court provided in that case, Your Honor, suggests or begs the question: why is it unreasonable for an insurance company to wait 5 days to send somebody out to look at this, but not unreasonable for an insured party to wait the same amount of time to report it? I think there's just the question there, why is, when the policy doesn't require immediate notice, why is there
so it's like a goose gander thing, it's good for the goose, it's good for the gander. Hey, you guys wait 5 days to come out, why can't I wait 5 days to tell you?
Right. And I think that that's part of the timeliness issue. If they don't have to act within, a certain period of time, or if they get 5 days to respond and investigate or even show up to inspect it, why would it be unreasonable for that same amount of time for the insured? And I would point out that it does seem like counsel is advocating for the court to impute some language into the policy that just does not exist. Prompt notice is not defined as instantaneous, immediate, day of the loss. There's no requirement in this policy that was argued or that I could reference, Your Honors. that requires pre-authorization by the insurance company for any emergency remediation measures or notice, within a certain period of time. So, in the answer brief, I believe, it was argued that they should have called the same day. There's no such requirement in the policy.
The case law has helped us to define prompt where the insurance company doesn't define in the policy. Judge
Correct.
Steele recently, as this year, writing for the Middle District, has collected a number of the cases. Prompt and other comparable phrases like immediate and as soon as practical do not require instantaneous notice. These phrases mean that notice should be provided with reasonable dispatch and within a reasonable time in view of all of the facts and circumstances of the particular case. And I think if we have a standard, that pretty much tells us what we're looking at in terms of defining prompt.
Correct.
And
Correct,
so
Your
the
Honor.
argument is, what are the facts and circumstances, as Judge Rothstein Yoakum pointed out, that fit into this analysis, and how much time do we need to look at?
Correct, Your Honor. And that's what we've argued in our briefs, and we've pointed out in several cases, many from this district, Your Honors, where it's been a question of timeliness.
I think I need to let you know your time is long since expired. In fact, expired before I made my comments. So I think we have concluded this one for better or for worse. And I thank you both for your presentations this afternoon. We are in afternoon, almost this morning. Thank you.
Thank you, Your Honors.
Thank you, Your Honors.